There you are. Okay, Ms. Perry, you're up.
Good morning, Your Honors. May it please the court. My name is Allison Perry, and I, along with Russell Marlowe, represent the appellant, who is a former wife, Constance Kerrigan. I'd like to reserve 5 minutes for rebuttal, please. This case.
Can I start off with one question? Okay. Very good. It's kind of bothering me. You've raised, I think, 2 points, correct? One or three, rather. See what they are. The Bent Cross mortgage, marital liability, the half the marital pay down of that mortgage, and you're wanting lump sum alimony of the one house. Assume, for these purposes, that we disagree with your first point, and we believe that the Bent Cross mortgage is a marital liability. Are you really better off getting a reversal on the pay down question? Because isn't that going to like reopen the equitable distribution and subject your client to potentially more liability than she's going to gain from getting part of the pay down?
Well, Your Honor, if she's already been charged with half the mortgage of the Bent Cross property.
It was assigned to him, though, correct?
It was a what?
That mortgage was assigned to him to pay.
It was.
What I'm saying is, if it's marital, is she going to be better off? You know, the judge, it's marital, it goes in his column, but he has to pay it.
Correct. But because he had to pay that, they also awarded him the only substantial marital assets.
Okay.
So they awarded him the Algerion's home.
So what happens if she gets the home and the part of the pay down and has to pay off half of that mortgage?
Well, she already has to pay off half that mortgage.
She was giving credit. He got credit for the whole mortgage, but she, you know, the mortgage has to be paid by someone.
Correct. But she's already charged with half the mortgage.
I'm just saying. Go ahead.
Okay. The former wife argues that the Bent Cross mortgage is not a marital liability because the judge found it to be marital because it was entered into during the marriage and she signed the mortgage. And this court in Frederick made it clear, which I cited to in my brief, that just signing a mortgage on a non-marital property does not make that a marital liability.
But doesn't this mortgage was incurred during the course of the marriage, correct?
Correct.
So doesn't that make it a marital liability under 61.075?
Well, you have to look if it's in non-marital assets include assets acquired and liabilities incurred by either party prior to the marriage, and assets acquired and liabilities incurred in exchange for such assets and liabilities.
You're looking at one subsection of 61.75, yes. But if you look at
61,
you look at the 6A1A, marital assets and liabilities include assets acquired and liabilities incurred during the marriage individually by either spouse or jointly by them.
Correct, but this is an exchange for this liability was an exchange for. Let me just can I get back to the Frederick case? Because in the Frederick case, the mortgage was taken out after the marriage.
I get it.
By the two parties. They both signed the mortgage. And this court found that that was not a marital liability just because she signed the mortgage.
Okay, go ahead. I'm sorry.
Just because she signed the mortgage, it was taken out.
Frederick treated it as a liability in exchange for equity, a non-marital equity in the property.
Correct. And
so
that's
there's a point where then the statute has an inconsistency, because you could look at it both ways. Ultimately, Frederick reached a result that would have been correct under either interpretation, did it not?
Yes. And that's the interpretation that we're seeking to have issued in this case.
Well,
that
here's the
just-
problem, though. The problem is the proceeds of this mortgage were used to fund their lifestyle. And while there's some allegations that it was used to do construction and improvements on the Bent Cross home, there really is no proof of that. I mean, the proof is that they were living beyond their means, traveling the world and living off borrowed money. And that the proceeds of this mortgage, not only was the mortgage taken out during the time of the marriage, she benefited from it. She enjoyed the travel of it and the lifestyle associated with it. Doesn't that mean anything?
I have not found anything written that says just because it was used for marital purposes, it becomes a marital debt.
Well, it's not just because, it was because, and that's in addition to the fact that it was taken out during the course of the marriage. So it's not just because it was used for her benefit. It's in addition to that, which, I could see the argument that, basically that just because she signed the mortgage and it was taken out during the marriage may not ipso facto make it a marital asset. But if she's enjoying the proceeds, that makes it a little bit more likely that, she benefited from it.
Well, that is distinguishable from Frederick. In the Frederick case, there was about a $73,000 mortgage taken out during the marriage, and $16,000 of it was used to improve the non-marital property. There's no evidence that the other portions of the mortgage were used for marital purposes. So that is distinguishable from Frederick. I will agree to that. The second issue on appeal is the former wife appeals the court's failure to award her the marital pay down on the Bent Cross mortgage. It was undisputed that $355,000 of marital assets were used to pay down this $1 million mortgage during the marriage. And that enhanced the non-marital value, which requires her to be entitled to half the pay down of that mortgage. And that's also addressed in the Frederick case. Are there any questions on that issue? No questions? And then the alternative, the wife argues that the lump sum, there should have been a lump sum alimony award if she's not awarded, if the two first issues are not reversed, because she leaves this marriage in misfortune. She leaves prosperity to misfortune.
So the first two issues are questions of law, basically, and the last issue is an abuse of discretion standard.
Yes, the first two issues are de novo, and the third issue is abuse of discretion. Except the judge erred when he failed to consider the husband's non-marital assets when determining his ability to pay. Because there is a rule of law that says you have to determine based on non-marital assets also, not just income and not just marital assets. And he had over $1 million worth of non-marital assets.
That being the home.
Yes, that he had the ability to pay the lump sum alimony in the form of the Algerins home, which is where this elderly wife was living. And she,
in the form of the other home, that was non-marital home, correct? Algerine was marital. And
correct. Correct. Algerines was marital home.
Didn't she initially plead for alimony though, and then waive it?
She did, but then she amended her petition to ask for lump sum alimony. So that issue was preserved. The marital pay down is an issue that if she's awarded, half of $355,000, that would make a substantial difference to this elderly lady's lifestyle, because she's left the marriage with basically $120,000 after living.
Again, we come back. So do you think that there would be cash to her for that? Or does she get, does it require a restructuring of the equitable distribution?
It has to do restructuring of the equitable distribution chart to credit her with to credit
or with 177, whatever, the half of
yes, that she should be entitled to $177,000 more from
of the marital assets.
So that would make a significant difference to her, because she's left this marriage without Were you going to ask something?
Well, I was thinking of something. Go ahead.
But she's left this marriage of 25 years. It's a long-term marriage. There's a presumption in favor of permanent alimony. Realizing the husband didn't have the ability to pay permanent alimony, he asked for lump sum alimony, and lump sum alimony can be awarded when there is a need and ability to pay, which the judge never got to the ability to pay issue here, because he just looked at the income of the parties instead of looking at the assets available to the parties. And here the husband does have the ability to pay without endangering his economic standing. So this is a perfect case where a lump sum alimony award should be awarded. And we also ask that she be awarded her appellate attorney fees in this case. So unless there are any other questions.
I don't think so. Thank you, Ms. Perry. Ms. Elvington?
Good morning. May it please the court, counsel, Brooke Elvington on behalf of Appellee, the estate of John Kerrigan. Starting first with the first two issues, which are somewhat intertwined, I'd like to turn back to Judge Morris's position, and that is, what were these funds used for? Meaning the Bent Cross mortgage, right? Because the wife takes the position and cites this court's position in Frederick and says, well, really what we're dealing with here is a wife who signed a mortgage, signed a note, and it occurred during marriage. And those two facts alone would not constitute a marital liability. And on that, I agree, with the exception that those variables have absolutely no relevance to the trial court's findings in this case. As this court noted in Frederick, in that case, the court analyzed the wife's action of signing a note as something that was almost ministerial, right? It literally had no impact on the marriage. There was no benefit to the marriage related to those mortgage funds. To the contrary, all of the benefit went to the other spouse and his premarital assets. Here, contrary to the wife's position, and this is on page 14 and 15 of the brief, the wife cites there was no evidence that the wife received any of the funds from the mortgage, and there was no competent substantial evidence that the funds were used for a marital purpose. That, of course, is in alignment with Frederick. However, that is completely contradictory to the volume of evidence we have in the record and to which the trial court relied upon. For instance, the wife in her own testimony admitted that the parties used the loan money to pay loans, pay their utilities, their vehicles, and their expenses. Record page 1475 through 6. She was impeached with her sworn deposition testimony, where she admitted that the loans were used to fund the party's business and home construction for the party's waterfront multi-million-dollar property, Skyline. That's page 1506. The husband testified that the funds were used for the party's lifestyle, travel expenses. These are people that accumulated more than 5 million airline miles during the course of their marriage, and their business investment. The forensic accountant testified that the parties essentially took out loans, paid them down, and then took out more loans in a revolving form of debt designed to fund their lifestyle. The accountant unequivocally testified that all of the Bent Cross loans were used to fund the party's lifestyle and that the parties lived well beyond their means. That is what the record supports. That is what the trial court based its factual conclusions on. And to Judge Northcutt, your question regarding the standard of review, while the determination of marital liability is reviewed under the de novo standard, that is a question of law, to the extent that the trial court relies upon its determination regarding credibility of facts or the factual findings, this court, of course, must defer.
Okay, but let me point out. Let me point out a couple of things. You know, I mentioned this to Ms. Perry. There's an inconsistency in the language of the statute. You know, by one, Frederick viewed the mortgage as an exchange for non-marital equity. Mm-hmm. Correct. And so correct. So that comes under the liability part of the statute. But On the other hand, the marital asset part says assets acquired and liabilities incurred during the marriage individually by either spouse or jointly by them, period. Full stop. So under that language, this would be a marital liability.
Yes,
No matter what,
absolutely.
you don't have to get to how it was used. The parties both, they were incurred, it was a liability incurred during the marriage.
I
So-
would agree. I would
And
agree.
Frederick reaches the same result that you would reach either way. But
It
it's
does.
not always going to be true.
That's true. If we look at the plain language of the statute, there's no question that this is a marital liability under the language of the
And you never
statute.
get to how the money was used.
You do not.
There might be some equitable factors for the overall equitable distribution if the money was used for a non-marital purpose. But in terms of it being a marital liability, there it is.
That's correct, Your Honor. And it would be no different from a party obtaining a credit card and us having to prove how those funds were used during the marriage unbeknownst to another party. We don't do that. It
Okay.
simply was acquired during marriage.
Can we go to the second issue on the pay down? And
Yes.
you've argued in your brief that pay down applies to premarital mortgages, non-marital. But none of you have cited us a case rather, that postdates the 2018 amendments to 61075. Now the judgment goes through, the pay down part that, it's 6A1C. And a marital asset is the pay down of principal of a note and mortgage secured by non-marital real property and a portion of any passive appreciation, etc. It doesn't say anything about a premarital note and mortgage.
Right. Your Honor, and that issue was not briefed. It also wasn't addressed at the
So
lower
you
level.
briefed it. You said it was only referred to premarital, and
Yes.
the statute doesn't say that anymore.
To that extent, I would agree with Your Honor. And what I would say is regardless what the language says, whether it's premarital or during the course of the marriage, here we don't have to get to that issue. And the reason we don't have to get to the issue is because the record would not support any credit for a pay down. And that is because the value of the pay down is unknown, right? What we know.
You can come close.
Well, we can't, right? And I would respectfully disagree. And that is because
Why
what
do you
we
say
have
there's no abilities? Okay, go ahead.
for two primary reasons. Okay. The first is we don't know the source of the pay down, right? Because most of the funds for the pay down, pursuant to even the wife's testimony, but most predominantly from the forensic accountant's testimony, is that the source of the pay down came almost entirely from the husband's retirement accounts, all of which were premarital.
Well, that's not what this language says.
Which language?
Doesn't say anything about the source of the pay down in the statute.
Well, except if the source of the pay down is entirely premarital, and we're looking.
She testified that they were making mortgage payments, correct?
Oh, she did. She said that they were making mortgage payments, and she also said that the husband was making payments as well through his retirement.
Okay,
And then
so let me just throw this out. If the statute says the pay down of principal of a note and mortgage without regard, doesn't say anything about the source, but you want to carve that out because saying that, well, you paid it all from non-marital sources, that would be your burden, correct? Because if we can't know that it all came from that, under this statute, wouldn't we have to, give the pay down?
Well, except the court has to be able to attribute a specific value and find that value in competent substantial evidence. And here we have 3 separate loans, all of which were subsumed within themselves. And that is why the forensic accountant testified that it was impossible to determine what the pay down was.
We know what the pay down was on the 1 million. And the fact that we don't know what the pay down was on the others would only benefit your client. But if the court only applied the pay down to the 1 million, which is all they're asking for in this case, that's to your client's benefit, is it not? because the statute says any pay down of any mortgage. And so theoretically, they could have sought part of the pay down of the other mortgages. But since those mortgages were fully satisfied or, taken care of by the last one, they're only seem to be going for that. But doesn't that benefit your client anyway?
Well, I suppose it would in that extent, but really the analysis we're doing here, the analysis we are attributing based upon the language that Your Honor is referring to, is that we are now going to take a debt that is presumably a marital debt, and we're going to assign that debt equally to both parties. But then we're also going to take whatever the balance was that was paid down, and we're going to give the other spouse half of that credit.
Yeah, because the credit, though, is you're talking about half the credit. The marital, what we used to call the marital estate, would have an interest in of credit for the whole pay down, and your client would get half and she would get half.
Right, which would be the same as a ordinary home that the couple shares, and you sell the home, and now we're giving half of a
I get it,
credit
but you know
for
what?
mortgage.
You know what? I don't write the statutes.
No, you're right. None of us write.
We're in a textualist world.
You are not incorrect on that point, Your Honor. But as I've indicated, I think we do have a problem calculating what that value would even be under the competent substantial evidence standard. The record simply does not demonstrate how that value could be assigned at the time of final hearing.
Yeah, but we could, for instance, there are numbers in the case where we could come up with a pay down amount, and it actually wouldn't capture all of it.
Right.
We know it would capture less than all of it.
Right.
Which is to your client's benefit, that fact.
Yes, I would agree. I would agree.
So right. So because we know that the $1 million mortgage was taken out 2 or 3 years after the marriage began, I think.
2004, I believe.
Or 2 or 3 years after we have a valuation. So I mean, we can't match it up exactly, but again, we give those 2 or 3 years, we don't count. It only starts, at that point. So it's to your client's benefit that we can't come up with a precise number. But there's a number that can be had here. Let me ask another question, and none of this was briefed, but the judge made reference to it. I think, the statute gives. So under the statute, someone can claim a share of the pay down and the portion of the passive appreciation that occurs beginning when the mortgage is first being paid with marital funds. And they haven't asked for that here. And there's a whole formula. There's a coverture factor. I'm sure you're familiar with this fact, but this is coverture factor and all that for how you come up with the marital, component of the passive appreciation. But then, but at the end of that subparagraph is a sub that says, the court shall apply the formula specified in this subparagraph unless a party shows circumstances sufficient to establish that application of the formula would be inequitable under the facts presented. Does that apply to the pay down as well? Or does that just apply to the passive appreciation? Because the judge cited equitable considerations, but I think it's debatable whether it applies to the passive appreciation because, to the pay down, because there's no formula specified.
Well, if we're going back to the plain language of the statute, then I would say no, right? If we're taking a textualist perspective, the answer is no. But the reason I would suggest that it's not briefed, obviously the reason I did not brief it is because it wasn't put in the initial brief. However,
right.
there was
nobody's looking for that appreciation issue.
Right, exactly. And there wasn't any competent substantial evidence presented to the court to establish evidence to use the formula, which is one of the issues that the trial court noted in the final judgment. But from a pure textualist perspective, and again, I think questions regarding—
I'm not an adherent to that
Right, I have.
I'm bound by what, I'm told.
Right. So one of the issues, of course, that we have in textualism is when you have inherently absurd results, right? And that's one of the issues that we have in reference to the mortgage pay down to begin with, and the entire analysis. So under that perspective, no, I don't think it would, because the language is not there. But when we're applying the same general legal principles, there would be no distinction between applying it for the appreciation in reference to the coverture fraction, the equation,
The
or
appreciation or the pay
yes,
down.
exactly.
Interestingly, though, in that formula for the appreciation is a clue to whether the pay down refers to a non-marital mortgage or premarital mortgage or not. And that is in sub 2, where it says the coverture fraction, you have numerator, denominator, but it depends on the denominator defined as the value of the real property on the date of the marriage, the date of acquisition of the property, or the date the property was encumbered by the first note in mortgage on which principal was paid from marital funds, whichever is later. And that means the property can be encumbered by a note in mortgage at later than the date of the marriage. And the coverture factor would apply. And that suggests to me that this does not refer just to premarital mortgages. The pay down doesn't refer to that either.
Yes, I mean, I'm looking at the same subsection, and again, you'll have to forgive me because this was not brief.
I get it. I get it.
So I am.
I'm trying to figure out whether you're right that this only applies to non-marital or premarital mortgages, and I'm questioning whether you are, given this contextual analysis.
Well, again, though, we're talking about. Okay, so in reference to your question as to whether it applies to premarital or encumbrances that occurred during the course of the marriage, we're talking about the date of the marriage, the date. Okay, but if we're including the language of the acquisition of the property within sub 2, right, and then we're talking about when that occurred, right? This statute is addressing marital property, right? So it does not, by inclusion of the date of the acquisition of the property, we are not suddenly changing the entire analysis under the statute to incorporate non-marital property simply by virtue of that phrase, right? This is detailing how the trial court must calculate what that appreciation is. Right? Meaning once the court has already made the determination that it is subject to distribution to begin with. This subsection does not alter that which is subject to distribution. It simply tells the court how to calculate appreciation associated with that which is subject to distribution.
But it does, as I said, it does talk about the date the property was encumbered.
Right.
The date of the marriage, acquisition, or the date the property was encumbered, whichever is later. So the encumbrance can post-date the date of the marriage, correct?
Sure, it can if the underlying asset is marital or the liability is marital. That's what I'm trying to suggest to the court, that this phrase applies to assets or liabilities that are already deemed appropriate for distribution. You are not going to use this phrase to that which is deemed non-marital.
The whole thing is, they get the pay down and the appreciation, passive appreciation. And the pay down language is pay down of principal of a note and mortgage secured by non-marital property. So that pay down is marital. And the passive appreciation that occurs thereafter is marital, according to the statute. There's always this attempt to deal with the principles in ka'a'a, and I don't think this statute actually does it correctly, but it says what it says.
Right.
So anyway, we're putting the panel to sleep.
We're talking about math, and we're about to talk about more math and alimony.
Right. Go ahead.
All right. So on the third issue, right, the question, of course, is whether the trial court erred by failing to award lump sum. And of course, lump sum is not a type of alimony, it is a method of payment. And I would, of course, refer back to the question as to whether alimony was pled. It actually was not. Originally, it was. Then the petition was amended to exclude it. And then finally, in the final amendment, the wife included alimony in sort of an alternative fashion. She pled for uneven distribution or in the alternative lump sum alimony. I did not argue on appeal that the trial court did not have discretion to even consider the issue based upon pleading deficiency because that was not argued below. So while I would suggest that it wasn't pled appropriately, that issue was not preserved, and I'm not arguing it now. So
How about the judge's reasoning that the estate, because now we're at the estate point,
right.
Judge Rosenberg, needs that house in order to pay its obligations. In the meantime, there's $800,000 in equity in that house.
Right.
So why does the estate need this other house?
To that question, I think it's important to make the distinction between uneven distribution and alimony, right? Because that argument goes to the heart of uneven distribution. That does not.
But I'm looking at the judge's, the judge's reasoning though.
Right.
Not giving either. I'm saying I question whether it holds up.
Right. So let's look at it, right? So to assess alimony, any type of alimony, and the court construed this as arguably durational because that's the only method that the court could construe it under the facts. To assess alimony, and I'm going to get pretty elementary here, we have to go back to need versus ability to pay, right? So the court found that the wife had a need for alimony. We don't challenge that here. There's competent substantial evidence to support it. The court likewise found that the husband did not have the ability to pay. Now, the ability to pay is premised upon current ability to pay. And
so you've got Maryland house with $800,000 in equity, and you got this house, which I think was it like 430 free and clear.
Yes.
How come the estate couldn't afford to let go of the free and clear? Because they still had the 800.
Because he wouldn't have the 800. And that is because the former husband did not have the ability to pay the $644,000 note associated with the house. He was using his premarital retirement fund, which was originally more than $2 million. And at the time of final hearing,
the $430,000 house ain't gonna pay that note either. The state's gonna liquidate it, correct?
He would liquidate it. No, he would liquidate it to pay off the note. And that was precisely what was
that wouldn't pay off the note.
No, but he would have.
But why couldn't he liquidate Maryland and pay off the note? He'd be left with $800,000 in his account.
Because then the trial court would have erred by requiring him to sell his sole residence.
Doesn't
Right?
doesn't require him to do that, but that's what he could do. He could afford to do that.
Except he couldn't, right? Because now we have to go back to general principles associated with alimony and the court's authority to grant it, right? So first, while the court must look at assets, the court is not permitted to impute income because, again, we're looking at income and ability to pay. The court cannot impute income from
the legislature totally done away with the concept of lump sum alimony.
Well, lump sum alimony is a method of payment, right? Method of payment only, not type of alimony, right? You have to first make that threshold determination regarding need and ability to pay. You don't get to jump over that to reach lump sum if you haven't first found that the husband has the ability to pay, and he doesn't have the ability to pay by virtue of selling his home. That is a principle that would certainly not be supported by any Florida law. In fact, Levine versus Levine, 29 Southern 3rd 464, that's 4th DCA 2010, held that the trial court should not impute income from a home that a spouse occupies after divorce. In support, and I apologize, I do not have the citation, but it's actually this court. The court, the Fourth DCA, cited this court's opinion, Suit versus Suit. That is spelled exactly how it sounds, SUIT versus Suit. In there, this court reasoned that the court should not force a party to change the character of an asset, right? So in other words, you cannot force a party to sell his sole residence for the purpose of establishing an ability to pay. That would be contrary to every position that we have
Okay.
pursuant to alimony,
Let
right?
me,
So, and in
let
fact,
me-
that is, go ahead.
let me interject that you and I have used up all your time.
Okay. I would simply sum by suggesting to the court that there is competent, substantial evidence in support of the court's rulings as to all three issues, and I would ask the court to affirm.
Okay, thank you, Ms. Elvington. Okay,
Thank
Ms.
you.
Terry to rebut.
Yes, first, I would like to say it was a husband's CPA that gave competent substantial evidence regarding the marital paydown of the mortgage. She testified that the Bent Cross mortgage had a balance of $644,326 at the time of the first bifurcated proceeding, which is when the marriage ended. And she agreed that the mortgage was, everyone agrees the mortgage was $1 million. So $1 million, that pay down would equal $355,674. That comes from their own witness. So there's competent substantial evidence to find what the marital pay down would be. Regarding selling the non-marital home of the husband to pay off expenses or to pay lump sum alimony, it's not just the former husband's income. That wouldn't be imputing income to him. He has assets, and the former husband's income alone is not the test for determination of the ability to pay alimony. There's case law, White v. White out of the Second District Court of Appeal that's cited to in the brief that says, you know, the former wife was entitled to alimony even if the former husband lacked income to pay alimony, even though the wife was healthy and employable. And here we have an elderly wife who's living in the Algerans' home. She's lived there for many, many years. She used much of her inheritance to pay for that home. It's found to be non-marital, I mean, it's found to be a marital asset, which she has not challenged. And as this court pointed out, the estate does not need that home. This lump sum alimony would give her the ability to stay in the marital home, the marital home as her non-marital asset. Well, if the marital home's awarded to her, she would be able to stay there. Right now, we have a motion for stay pending before this court. So she's still residing in the marital home. As you know, Judge Northcutt pointed out, the estate has the ability to pay this lump sum alimony without endangering the estate. The estate will still have the ability to pay off the mortgage with the Bent Cross property. And there's just no reason not to award her lump sum alimony in the form of the Algerans' home. It's a court of equity, and that would be equitable. Are there any other questions?
No,
Okay.
I'm sorry.
Okay, Your Honor. Thank you so much.
Okay, thank you both very much. In order to leave our virtual courtroom, you need to click the Zoom leave button, which depending on which version of Zoom you have, is either a little red button that says leave or a little red figure of a man or a woman even, I guess. But
Thank you, Your Honors.
thanks a lot. And with that, we're adjourned.